The marble halls of America's highest court had never seen anything like this. Justice Stephen Breyer, the 85-year-old legal titan with 5 decades of experience, sat across from Congresswoman Jasmine Crockett in what was supposed to be a routine legal symposium. But what happened next shattered every expectation in the room. Breyer leaned forward and spoke 7 words that would change everything. "Congresswoman, you are absolutely brilliant." The entire courtroom fell into stunned silence. Legal scholars froze mid-thought. Court reporters stopped typing. Even the security guards turned their heads in disbelief. But it wasn't just a compliment that left everyone speechless. It was what Jasmine Crockett did next. A move that would send shockwaves through the legal establishment and spark a viral moment the political world is still talking about. Before we dive into this extraordinary story, let me know in the comments where you're watching from. And don't forget to hit that subscribe button so you never miss moments like these, moments reshaping American politics in real time. To understand why this moment was so explosive, you need to know who these 2 people are and why their meeting was so significant. Justice Stephen Breyer had spent his entire career as the ultimate Washington insider. Appointed to the nation's highest court in 1994, he authored landmark decisions that shaped American law for decades. At 85, he was considered one of the most respected legal minds in the country, a man who had seen presidents rise and fall, who had debated constitutional law with the brightest minds of his generation. But in recent years, Breyer had come to symbolize something else: the old guard. Critics whispered that he was out of touch with modern America, too comfortable with the status quo, too far removed from the real struggles of everyday people. On the other side of the room sat Jasmine Crockett, the 43-year-old freshman congresswoman from Texas who had been turning heads since the day she arrived. A former civil rights attorney with degrees from 2 prestigious universities, Crockett had quickly earned a reputation as one of the sharpest legal minds in Congress. But she also represented something that unsettled the establishment. She was unafraid. Unafraid to call out hypocrisy, unafraid to challenge authority, unafraid to speak truth to power in ways that made career politicians squirm. The legal symposium was intended to be routine, distinguished speakers discussing constitutional law with students and young attorneys. But when the organizers paired Breyer with Crockett for a panel on modern challenges to constitutional interpretation, they unknowingly created a powder keg. The stakes could not have been higher. In an America divided along every imaginable line, here were 2 brilliant legal minds from different generations, different backgrounds, and different worldviews, about to clash on the most fundamental questions facing democracy itself. The audience of law students, professors, and practitioners had expected a scholarly discussion. What they were about to witness was something far more dramatic, a masterclass in legal brilliance that would reveal just how deeply the establishment had underestimated a young congresswoman. The tension began building the moment they stepped on stage. Justice Breyer, in his trademark navy suit, carried himself with the calm authority of a man who had spent 3 decades on the nation's highest bench. He nodded politely to Crockett as they settled into their chairs, but there was something in his demeanor that suggested he saw this as just another appearance, an opportunity to share wisdom with a younger colleague. Jasmine Crockett, dressed in a sharp burgundy blazer that demanded attention, scanned the room with the keen eyes of someone who had spent years in courtrooms where every word mattered. She had prepared for this moment far more thoroughly than anyone realized. The moderator opened with easy, softball questions about constitutional interpretation, and at first, everything went as expected. Breyer spoke in measured tones about judicial philosophy, citing cases from memory with the ease of a seasoned jurist. He spoke from memory with the ease of someone who had helped decide those very cases. The audience nodded respectfully, taking notes on every word from the distinguished justice. For nearly 20 minutes, the discussion followed the predictable rhythm of events like this. Law students asked deferential questions about landmark rulings. Professors posed theoretical inquiries about judicial methodology. Breyer responded with the polished eloquence of a man who had delivered thousands of such presentations across his decades-long career. But Crockett remained strikingly quiet during this opening phase. She scribbled the occasional note, yet mostly she observed. Those who knew her background in law understood the strategy. She wasn't disengaged. She was studying her opponent, waiting, timing her moment. As a former trial attorney, she knew the value of letting someone stake out their position before unveiling her own. The turning point came when a third-year law student raised a question about balancing judicial restraint with protection of individual rights. Breyer launched into his well-worn answer about the challenges of constitutional interpretation in a democracy, stressing the importance of deferring to elected officials while still safeguarding fundamental liberties. It was then that the air shifted, perhaps sensing the need to inject energy into what had become a standard academic exchange. The moderator pivoted to the hot-button issue of voting rights, one of the most polarizing debates of recent years. Breyer delivered his standard response, emphasizing complexities of balancing state and federal authority. But as he spoke, eyes in the crowd noticed Crockett lean forward ever so slightly, her pen halting mid-sentence as her focus narrowed on his words. The shift was subtle, but unmistakable to anyone familiar with courtroom dynamics. The prosecutor in her had spotted an opening. That's when Crockett leaned forward, her posture signaling to anyone who knew her she was about to strike. "Justice Breyer," she began, her voice carrying the controlled intensity of a seasoned litigator. "With all due respect, I think we need to be honest about what's really happening here." The atmosphere changed instantly. This wasn't the deferential tone everyone expected from a freshman congresswoman addressing a Supreme Court justice. This was the voice of an equal and of a challenger. "When we talk about balancing federal and state authority and voting rights," Crockett continued, "we're using language that sounds neutral and scholarly. But in reality, that so-called balance has been used to justify the systematic disenfranchisement of millions of Americans, particularly black and brown voters." Murmurs rippled through the audience. Some shifted uncomfortably in their seats. This was not how symposiums typically unfolded. Breyer's eyebrows rose slightly. He was no stranger to disagreement. He was used to being challenged. But something about Crockett's tone, the precision of her language, pulled him in. "Congresswoman," he replied, still measured but now unmistakably engaged, "surely you understand that constitutional interpretation requires us to rise above political considerations and focus on legal principles." The audience collectively held its breath. They sensed it. This was no longer an academic panel. Crockett didn't flinch. If anything, she pressed harder. "Justice Breyer, I practiced civil rights law for years before I came to Congress. I've seen firsthand how rising above politics often means ignoring the real-world impact of legal decisions on real people's lives. When we treat constitutional interpretation as an abstract exercise, divorced from consequences, we're not being principled, we're being privileged." The temperature in the room seemed to drop. Legal scholars traded uneasy glances. Students stopped writing notes and instead lifted their phones to record. This was unprecedented. A sitting congresswoman openly challenging the philosophical core of a Supreme Court justice's approach to law. But Crockett wasn't done. She reached for a folder she had carried onto the stage, which until now had seemed like simple preparation. As she opened it, the gesture was unmistakable. This was evidence. "Let me give you a specific example," she said, flipping it open with the practiced precision of an attorney in trial. "In your dissent in the recent Alabama redistricting case, you wrote that the majority's decision would unduly burden state sovereignty. But Justice Breyer, that very decision you criticized protected the voting rights of hundreds of thousands of black voters who otherwise would have been effectively disenfranchised." The silence in the room was now total. Even the court reporters seemed frozen. "So my question is this," Crockett pressed on. "When we prioritize abstract concepts like state sovereignty over concrete protections for voting rights, whose interests are we truly serving? And how do we justify that to the communities whose voices are being silenced?" Justice Breyer sat back in his chair, his expression unreadable. For several long seconds, the only sound in the room was a low hum of the air conditioning. Everyone waited to see how one of the most powerful jurists in America would respond to being directly challenged by a freshman congresswoman. But what happened next stunned everyone, including Jasmine Crockett herself. Instead of the defensive pushback many had anticipated, Breyer's expression began to shift. The faint frown of a man being criticized slowly gave way to something else entirely. The look of genuine admiration. "Congresswoman Crockett," he said at last, his voice carrying a new tone of respect. "That is an exceptionally well-crafted argument." The admission rippled through the audience in shock, but Breyer wasn't finished. "Your point about the relationship between legal abstraction and real-world consequences, I have to say, that is exactly the kind of thinking the legal profession needs more of." Then came the moment that would be remembered for years. Justice Breyer rose from his chair, an almost unthinkable move in such a formal setting. The audience watched riveted as the 85-year-old justice began pacing, visibly working through the implications of what Crockett had just laid out. "You know," he said, turning to face her directly, "I've been wrestling with these issues for decades. But the way you framed this challenge, it's forcing me to reconsider some fundamental assumptions." The room was electric. Students openly recorded now, sensing they were witnessing legal history unfold. And then Breyer did something no one could have predicted, something that left even the most seasoned legal veterans stunned. He walked over to where Crockett sat, extended his hand, and spoke the words that would echo through the legal world for years to come. "Congresswoman, you are absolutely brilliant. I mean that sincerely." The reaction was immediate. Gasps, dropped jaws, stunned faces all around. The moderator looked frozen. Even the security guard seemed shaken by the unprecedented display of respect from a Supreme Court justice toward a freshman congresswoman. But what happened next was even more extraordinary. Jasmine Crockett, who had spent her entire career fighting to be taken seriously in rooms dominated by powerful men, who had endured years of being dismissed, talked over, underestimated, simply sat still for a moment, silent. The entire room could see the emotion on her face. It wasn't just surprise. It was a weight of years of struggle, years of proving herself, crystallizing into this single moment. When she finally spoke, her voice was steady, but it carried the resonance of someone speaking from the depths of experience. "Justice Breyer," she said, rising to meet his handshake, "I appreciate that more than you know. But I didn't come here today seeking validation. I came here because these issues are too important for us to approach from a place of comfort or assumption." She paused, turned to face the audience of law students and legal professionals. "What I hope this conversation shows is that all of us, no matter our experience, no matter our position, have a duty to keep questioning, to keep challenging, to keep pushing one another to be better. That includes questioning Supreme Court justices when necessary." The room erupted in spontaneous applause. But Crockett raised her hand, signaling for quiet. She wasn't done. "Justice Breyer, your willingness to truly engage, to admit when an argument makes you reconsider, that is intellectual honesty. And that is exactly what we should demand from every leader, including ourselves." And then came the defining gesture of the night. Crockett opened her folder once more and withdrew a document, sliding it toward Breyer. "This is a brief I've been working on regarding voting rights legislation, currently before Congress. After this discussion, I'd like to invite you to review it. Not for any official opinion, of course, but because I believe the arguments might interest you." The boldness of the move was breathtaking. A freshman congresswoman was, in essence, inviting a Supreme Court justice to examine her work as a peer, not as a subordinate. But the shock deepened when Breyer didn't just accept the document. He began flipping through it immediately, scanning page after page as the audience watched in stunned silence. His eyebrows rose as he read. "Congresswoman," he murmured, still studying the citations, "you're building on the precedent from the 1965 cases, but connecting it to modern data analysis. This is sophisticated legal reasoning." The audience was transfixed. A Supreme Court justice was offering real-time feedback on a congresswoman's legal brief. Law students scribbled furiously, recognizing they were witnessing something that would be studied for decades. "The way you've structured the equal protection argument here," Breyer continued, pointing to a section, "this could actually strengthen the constitutional foundation for federal voting rights legislation." He looked down at the brief, then back at Crockett, and then something remarkable happened. He smiled, not the polite, diplomatic smile of a public official, but the warm, genuine smile of someone who had just been surprised and impressed. "Congresswoman," he said, "I would be honored to read this, and I suspect I may even learn something from it." The audience was spellbound. Cameras recorded as the two stood facing one another, mutual respect radiating between them. But Crockett had one more surprise. "Justice Breyer," she said, her eyes scanning the room. "You mentioned profession needs more of this kind of thinking. So what if this conversation isn't just an ending, but beginning? What if we challenged every law school in America to host dialogues like this? Not just between justices and members of Congress, but between judges and civil rights lawyers, between scholars and community advocates, between anyone willing to wrestle honestly with these questions." The energy in the room surged. Students nodded, professors exchanged excited glances, and audience members pulled out their phones, not for social media, but to take notes. They knew they were watching history. "We could call it the Honest Dialogue Project," Crockett declared. "A commitment to have the hard conversations about law and justice in America, even when they make us uncomfortable." Uncomfortable. A law professor in the third row raised her hand and called out, "Congresswoman, how would this differ from the typical academic conferences we already have?" Crockett turned to address her directly. "Professor, the difference is accountability and real-world impact. Academic conferences often become echo chambers where like-minded people reinforce each other's views. What I'm proposing is structured dialogue between people who disagree but disagree, substantively with preparation and evidence, not just talking points and political theater." She paused, looking around the room at the engaged faces. "Think about what just happened here. Justice Breyer and I come from different backgrounds, different generations, sometimes different perspectives on legal interpretation. But because we both came prepared with substantive arguments and approached each other with respect, we were able to have a meaningful exchange that advanced conversation rather than just scoring political points." A student in the back called out, "But Congresswoman, how do you ensure these dialogues don't just become platforms for people to grandstand?" The question drew appreciative murmurs from the audience. It was exactly the kind of practical concern that would determine whether such an initiative could succeed. Crockett smiled, clearly pleased by the thoughtful question. That's exactly the right question to ask. The answer is structure and accountability. Participants would have to submit their arguments in advance, include citations and evidence, and commit to engaging with counterarguments rather than just restating their positions. She gestured toward Justice Breyer. "Notice how our exchange worked. I didn't just say voting rights are important. I cited specific cases, pointed to concrete consequences, and presented evidence. Justice Breyer didn't just dismiss my concerns. He engaged with the substance of what I was saying. That's the model." Justice Breyer nodded approvingly. "The Congresswoman is absolutely right. The structure matters enormously. In judicial conferences, we have protocols that force us to engage with the strongest version of opposing arguments, not just the weakest ones. That's what elevates the discussion." Justice Breyer's eyes lit up with interest. That's actually a fascinating idea. Congresswoman, the kind of cross-pollination of ideas that could really advance legal thinking. What happened next would be replayed on social media millions of times. Justice Breyer turned to the audience and said, "I want everyone here to understand what just happened. Congresswoman Crockett didn't just present a legal argument. She presented a vision for how we can do better, how we can push each other to think more deeply, more honestly, more courageously about the law and its impact." He paused, looking directly at Crockett. "This is exactly the kind of leadership the legal profession needs. And frankly, it's the kind of leadership America needs." The standing ovation that followed was unlike anything that had ever been witnessed in that formal setting. But the real impact of the moment was just beginning. Within minutes of the event ending, something unprecedented began, happening across social media platforms. Videos of Justice Breyer calling Jasmine Crockett absolutely brilliant started spreading like wildfire, but they were accompanied by something even more powerful: the full context of their exchange. The initial clip that went viral was just 30 seconds long. Justice Breyer's admission followed by Crockett's composed response. But what made this different from typical political viral moments was that people weren't just sharing the clip, they were sharing longer segments that included the substantive legal arguments that led to that moment. A legal journalist who had been in the audience live tweeted the entire exchange, creating a thread that was retweeted over 50,000 times within the first hour. This wasn't just a moment of recognition, she wrote. This was a masterclass in how legal discourse should work. Thread 127. But the real indicator of the moment's significance came from an unexpected source. Law students across the country began organizing viewing parties to watch the full video together. At universities, from coast to coast, students gathered in common rooms, lecture halls, and coffee shops to dissect not just what was said, but how it was said. A first-year law student at a prominent university posted, "Watched the Crockett-Breyer exchange with my study group tonight. We spent 3 hours afterward discussing constitutional interpretation. That's 3 more hours than we've ever spent voluntarily discussing constitutional law. This is what inspired legal education looks like." The ripple effects extended beyond just sharing clips. Legal blogs that typically attracted modest readership saw traffic spikes as people searched for deeper analysis of the constitutional questions Crockett had raised. Academic legal databases reported unusual increases in searches for voting rights cases and federal-state jurisdictional precedents. Legal, Twitter, usually a fairly insular community, exploded with commentary. But this wasn't the usual partisan bickering that dominates political social media. Instead, law professors, practicing attorneys, and legal scholars from across the political spectrum were sharing clips and expressing genuine amazement at the level of discourse they just witnessed. Prominent constitutional law professor at a major university tweeted, "I've been teaching constitutional law for 20 years, and I've never seen a more compelling real-time demonstration of how legal dialogue should work." Crockett's preparation and argumentation were masterful. Another legal scholar added, "Justice Breyer's willingness to engage genuinely with challenging questions and his recognition of Crockett's brilliance shows why intellectual humility is so important in legal thinking." But the impact went far beyond legal circles. The video clips were being shared by people who had never heard of constitutional law symposiums, but were captivated by watching two brilliant minds engage respectfully with difficult questions. The hashtag Honest Dialogue, inspired by Crockett's proposed project, began trending within hours. Law schools across the country started announcing their intention to host similar events. The dean of one prestigious law school issued a statement saying, "Congresswoman Crockett has challenged us to do better, and we're accepting that challenge." However, not everyone was pleased with what had transpired. Some conservative commentators attempted to frame the exchange as inappropriate, arguing that a congresswoman shouldn't challenge a Supreme Court justice so directly, but these criticisms were quickly overwhelmed by a surprising source. Other conservative legal scholars who praised both Crockett's argumentation and Breyer's intellectual honesty. A well-known conservative law professor wrote, "Regardless of one's political views, what we witness today was exactly how legal discourse should work." Crockett came prepared with substantive arguments, presented them respectfully but firmly, and Breyer responded with the intellectual honesty we should expect from all jurists. This is what productive disagreement looks like. The praise wasn't limited to academics. Practicing attorneys began sharing stories of how the exchange had inspired them to approach their own legal arguments differently. A civil rights attorney in Atlanta posted, "Watching Jasmine Crockett yesterday reminded me why I went to law school. Her ability to challenge power while maintaining respect and dignity. That's advocacy at its highest level." But perhaps the most significant immediate impact was on law students and young attorneys. The comment sections of the viral videos were filled with aspiring lawyers expressing how the exchange had changed their understanding of what legal advocacy could look like. One second-year law student wrote, "I've been struggling with whether I want to continue in law school because so much of what we study seems disconnected from Real justice. Watching Congresswoman Crockett yesterday reminded me that law can be a tool for real change when wielded by someone with her courage and preparation. The formal legal establishment also took notice. The American Bar Association announced plans to incorporate the honest dialogue concept into their continuing legal education programs. Multiple bar associations issued statements praising both participants for demonstrating the highest ideals of legal discourse. Within 48 hours, Congresswoman Crockett's office reported receiving invitations to speak at over 30 law schools. Her staff was inundated with requests from legal organizations, civil rights groups, and educational institutions wanting to host similar dialogues. Justice Breyer, through unofficial channels, let it be known that he had indeed read Crockett's voting rights brief and found it exceptionally well-reasoned. While he couldn't comment officially on it, in the weeks that followed, word began to spread about Justice Breyer's surprising openness. Insiders revealed that his exchange with Jasmine Crockett had left him invigorated, pushing him to seek out new perspectives on constitutional questions. Early events from the Honest Dialogue Project confirmed what many had long suspected. There was a deep hunger in the legal world, and far beyond it, for meaningful engagement with tough issues. Unlike the shallow political theater that so often dominated public life, these conversations drew people in because they were real. They showcased intelligent, well-prepared individuals wrestling with complex questions respectfully and directly. For Jasmine Crockett, the symposium became a turning point. Overnight, she transformed from a promising freshman congresswoman into a nationally recognized voice for principled advocacy. Speaking requests flooded in from across the country. Legal organizations sought her insights. Commentators began calling her a rising star with potential to shape American legal and political discourse for decades to come. But the shift wasn't only about reputation. Something deeper was unfolding within Congress itself. Members from both sides of the aisle began treating Crockett differently. They recognized that her expertise wasn't just impressive, it was indispensable. A senior Republican senator, known for his own legal acumen, quietly approached her for advice on constitutional questions surrounding pending legislation. "I may disagree with your politics," he admitted, "but I can't argue with your reasoning. If we're going to write good laws, we need people who understand the Constitution as well as you do." Her own party took notice too. Democratic leadership began pulling her into high-level strategy sessions. She wasn't just another freshman now. She was helping shape the party's approach to Supreme Court nominations, constitutional challenges, and critical legislative debates. In hearings, her questions were no longer brushed aside. They carried weight. When Jasmine Crockett spoke, people listened. That fact became crystal clear just 2 weeks after her exchange with Justice Breyer during a high-profile Judiciary Committee hearing. A federal appeals court nominee had been gliding through his confirmation with rehearsed answers until Crockett's turn came. "Judge," she began, opening the same folder she had carried into the symposium. "In your written responses, you emphasize faithful adherence to constitutional text and original meaning. I want to understand how you apply that in practice. In your 2019 opinion in Martinez versus State Election Board, you argued that federal oversight of state election procedures should be extremely limited to protect state sovereignty. But your reasoning relied heavily on a 1903 case, one that predates the 15th Amendment's enforcement provisions and the Voting Rights Act. How do you reconcile strict originalism with the clear evolution of constitutional understanding regarding federal authority to protect voting rights?" The room froze. Senators glanced up from their phones. The nominee shifted in his chair, unprepared for such a pointed constitutional analysis. Congresswoman Crockett, those circumstances were..." She cut him off, calm but firm. "Here's what troubles me. You cite the original meaning of the Constitution's text, but ignore the original meaning of the Reconstruction Amendments, which were explicitly written to expand federal authority to safeguard voting rights. Isn't that selective originalism?" Gasps rippled across the chamber. Her question exposed a glaring contradiction in the nominee's judicial philosophy, one no other senator had caught. Within hours, legal experts were calling it the most substantive moment of the confirmation hearings. Yet those closest to her knew Crockett wasn't chasing headlines. If anything, she was doubling down on preparation. Staffers reported she was spending longer hours poring over case law, determined to keep raising the standard of discourse. She's always been brilliant, one colleague remarked. The difference is, now everyone sees it, and she's reminding us that in American politics, substance still matters. The exchange had also left its mark on Justice Breyer. Colleagues noted a shift in his final months on the bench, an energy, a willingness to wrestle openly with difficult questions. His last opinions bore the imprint of deeper engagement with the real-world impact of legal decisions. Law schools across the country soon made the Crockett-Breyer dialogue required study material. Professors urged students to analyze not only what was said, but how. The preparation, the respect, the intellectual honesty. One constitutional law professor told her class, "This is advocacy at its best." Notice how Crockett came armed with substantive arguments, presented them firmly but respectfully, and how Justice Breyer responded, not with defensiveness, but with humility. That's the standard you should all aspire to. The impact reached beyond careers, beyond even the legal profession. At a time when many Americans doubted whether meaningful dialogue across divides was possible, their exchange stood as proof that it was. Political scientists dissected it as a case study in democratic discourse, an example of how preparation, respect, and courage could bridge divides without resorting to cheap theatrics. It was, in short, a viral moment of substance in an age of performative conflict. A reminder that excellence in preparation and argumentation could still be recognized across political and generational lines. The story of that day, when Justice Breyer called Jasmine Crockett brilliant, and she used the moment not for validation but to challenge the entire profession to do better, became something larger than either of them. It became a symbol of what American law and politics could aspire to be: substantive, respectful, challenging, and rooted in the pursuit of justice. As one observer put it, in a single exchange, Jasmine Crockett showed us that politics and law, at their best, are about engaging with the hardest questions, not avoiding them. And Justice Breyer reminded us that true wisdom requires humility to recognize brilliance wherever it appears. Together, they offered a glimpse of the leadership America desperately needs. And the lesson for lawyers, politicians, students, and citizens alike was clear. Preparation, respect, intellectual honesty, and the courage to confront difficult questions aren't just professional virtues. They're democratic virtues. And when those virtues are paired with the kind of brilliance Jasmine Crockett displayed that day, they don't just win arguments. They change minds. They elevate discourse. They remind us what's possible when we bring our best selves to the most important conversations of our time. So, what did you think of Jasmine Crockett's performance? Share your thoughts below. And don't forget to spread this story to anyone who still believes substance matters in American politics.